Bismillahirrahmanirrahim. I am Aown Abbas. Today's my presentation topic is negotiation in law, a Pakistani legal perspective. Negotiation is an essential component of the legal process, enabling parties to resolve dispute without prolonged litigation. In Pakistan, this concept is deeply intertwined with both traditional and modern legal frameworks, reflecting a unique blend of Islamic principle and British colonial legal heritage. This presentation explores the evaluation key legislation, practices, and challenges surrounding negotiation with the Pakistani legal system. The aim to provide a comprehensive understanding to how negotiation shape justice delivery and dispute resolution in Pakistan today. Defining negotiation principle and legal framework. Negotiation defined. Negotiation is a process in which two or more parties communicate and bargain to reach a mutual acceptable agreement or resolve a conflict. It typically involves discussion, different interest making efforts, and counter offers and seeking common ground. Negotiation can occur in various settings, such as business, legal matters, personal relations, and international diplomacy. Core principle. Negotiation is guided by several core principles that help parties reach effective and fair agreements. One key principle is focusing on interest rather than position, ensuring that the underlying need of both sides are addressed rather than rigid demand, striving to mutual benefits, promote win outcomes where all the parties feel satisfied. Preparation is essential, including knowing your goal and the alternative. Effective communication through active listen and the clear expression is vital to understanding and resolving issue. Building trust and maintaining respectful relationship. Create a cooperative atmosphere while the beginning flexible allow to creative problem solving. Lastly, using to objective criteria such as data and standard help ensure to fair and reduce a conflict. Legal framework. The legal framework of negotiation refer to set a laws, regulations, and ethical guidelines to govern how negotiations are conducted, especially in formal or contractual contexts. It ensures that negotiations are fair, transparent, and legal binding when agreements are reached. Key elements include contract law, which govern enforced to agreements, good faith principle requiring honesty and fairness, confidentiality rule, especially in business deals and dispute resolution mechanisms, such as mediation or arbitration. This framework protects the right to all parties and helps prevent fraud or mispresentations. Historical roots negotiation in Islamic jurisprudence and colonial law. Islamic jurisprudence. In Islamic jurisprudence, negotiation is grounded in principles of justice, mutual consent, and honesty. Classical Islamic contracts emphasize fair dealing and mutual benefits with negotiation, used to settle disputes, form trade agreements, and resolve conflict through peaceful dialogues. The concept of sulah, amicable settlement, was especially important in resolving both civil and criminal disputes, promoting reconciliations over confrontations. Colonial influence. Colonial influence on negotiation often reflected power imbalance, where European colonial power negotiation with indigenous leaders from the position of the dominance. These negotiations frequently resulted in treaties and agreements that favored colonial interest, often exploiting local resources and undermining the traditional system. Many such agreements lacked genuine consent involved or were the misunderstood by local parties due to language and cultural differences. As a result, colonial negotiation offered the disturb to long-term conflict, mistrust, and legal dispute. that continue to affect post colonial societies today. Integration. Modern Pakistani law balance religious injunctions with civil procedure, promoting negotiation with both spheres. In some religious element of the both system were blended, resulting in hybrid legal framework where the traditional Islamic principle coexist with the Western contractual law. The integration continued to shape the modern negotiation practices in many Muslim majorities countries, influencing how to agreement for the resolve and justice persuade. Key legislation, Contract Act, CPC and ADR mechanisms. Contract Act 1872. The Contract Act provides the legal foundation for forming valid and enforceable agreements, outlining principles like free consent, considerations, and lawful object. Civil Procedure Code. The CPC governs the procedural aspect of civil dispute, allowing court to ensure settlement through negotiation or mediations. Alternative dispute resolution. ADR mechanisms such as mediation, arbitration, and conciliation offer formal alternatives to litigation, promoting negotiated settlement that are often faster, cost effective, and less adversarial. Together, these laws supported structured, fair, and legally recognized negotiation processes. Negotiation strategies best practice for legal professionals. Preparation. Preparation for legal negotiation it involves understanding the legal context, knowing your case thoroughly, setting clear goals and identify your batna, analyzing the other party's interest, planning concessions, organizing documents and rehearing possible scenarios all help ensure a confident and strategic approach. Effective communication. Effective communication is key to successful legal negotiation. It involves being clear, concise, and persuasive while maintaining a professional and respectful tone. Active listening is essential. Understanding the other party's perspective can reveal opportunities for compromise. Avoid legal jargons when possible to ensure clarity and summarize key points to confirm mutual understanding. Nonverbal clues such as body language and tone of voice also play a vital role. Staying calm, assertive, and empathetic help building trust and keep the negotiation focused on solution. Flexibility and creativity. Flexibility and creativity are essential traits in legal negotiation. Flexibility allows legal professionals to adapt to new information, changing dynamic and unaccepted counter offer without compromising core objectives. Creative thinking help in generation alternative solution that satisfying both parties interest, often uncovering win come outs that is not immediately obvious. By thinking to beyond the traditional and position and being open the innovatives and term or structure, lawyer can break deadlock the relationship and achieve more favorable result for their clients. Ethical conduct. Ethical conduct is fundamental in legal negotiation, ensuring integrity, fairness, and compliance with professional standards. Legal professionals must be honest in representations, avoid misleading statement, and respect confidentially at all time. They should not exert undue or exploit the opposing party to weakness unethically. Adhering to rule the professional responsibility, such as those set by bar association in crucial. The ethical negotiator main to transparency seek to inform the consent for client and always act their best interest while respecting to right and position to other involved to negotiations. Case studies successful negotiation in Pakistani courts. Land dispute resolution. Land dispute resolution in Pakistan typically involve legal proceeding in courts or alternative dispute resolution ADR method like mediation and arbitration. These disputes often concern issues such as ownership, illegal land grabbing, or encroachment. Court cases can be lengthy while ADR offer a quicker, mutually agreement solution. For instance, large scale land dispute like those involving Barrier Town, Karachi may involve negotiated settlement and pay arrangement facilitated by the court ensuring to fairness and the protecting of the property right. Family law matters. Family law matter in Pakistan deal with issues like marriage, divorce, child custody, inheritance. Primarily governed by Islamic law, divorce can be initiated through talaq, husband or khula wife, and child custody decision focus on the child welfare. Mediation is encouraged to resolve conflict and courts intervene when the necessary to ensure fair maintenance, assessed divisions, and child support. Islamic inheritance laws guide to division of the property in family dispute. Commercial contract settlements. Commercial contract settlement in Pakistan involve resolving dispute between parties in business agreement, typically related to breaches, payment issues, or non-fulfillment or contractual terms. These disputes are usually settled through negotiation, mediation, arbitration, or litigations, depend on the nature of the contract and the preference of the parties involved. In some cases, parties may seek mediation or arbitration as the alternative to lengthy court proceedings, as these methods tend to be quicker and more cost effective. If an agreement cannot be reached, the case may proceed to court, where the judge will interrupt the term of the contract based on the local law, commercial practice, and the precedent. Successful settlement often involve compromise, ad- adjustment to the terms, to financial compensation to resolve the matter in way that benefit both parties. Challenges and pitfalls, ethical consideration, and power dynamics. Power imbalance, unequal bargaining power, risk, and unfair agreement. Power imbalance in negotiation can lead to unfair outcomes, with the strong party pursuing or exploiting the weaker ones. It raises the ethical concern, limit open dialogues, and damages trust. Addressing it requires strong alternative transparency and objective standard to promote fairness. Confidentiality issues. Confidence issues in negotiation can hinder effectiveness and lead to unfavorable outcome. A lack of confidence may cause hesitation or avoiding assertive communication. This can result to accepting poor term or failing to advocate for important interest. Confidence issues often stem from fear of rejection, inexperience, or building confidence through preparation, understanding one value, and the practicing negotiation skill is key to engaging effective or showing better outcomes. Ethical dilemmas and ethical dilemmas in negotiation arise when a person faces a choice between two or more conflicting moral principles, where the honoring one may violate another. Enforceability. Enforceability in negotiation refers to extent to which the agreed term to be legally or contractually upheld. A deal must be clear, lawful, or mutually agreed upon to be enforceable. It is agreement lacks specialty, involve unethical practices, or violate law. It may not hold up in court or arbitration. Ensuring enforceability protects both parties, promote accountability, or reduce the risk of future dispute. Clear documentation, legal review, and mutual understanding are key to achieving enforceable outcomes. The future of negotiation ADR and modernizing the legal system. Technological integrations. Technological integrations in negotiation is how parties communicate, prepare, and resolve dispute. Tools like AI-powered analytics, virtual negotiation platforms, and blockchain-based smart contract and enhance efficiency, transparency, and accuracy. These technologies assist to evaluating offer, predicting outcomes, and managing documentation in real time. Outline dispute resolution ODR system, allowing negotiation to occur across border without the physical meeting, making the process more accessible. However, religions on technology also arise the concern around data privacy, digital equity, and ethical use of AI. Overall, teach integration are streamlining negotiation while the reshaping tradition practice for the more connected and informed future. Legislative reforms. Legislative reform in negotiation refer to change or improvement in law and the policies that impact how negotiations are conducted, particularly in government, business, and international relations. These reforms may focus on enhancing transparency, ensuring fairer processes, addressing power imbalance, and incorporating ethical standards in negotiation practice. Training and capacity building. Training and capacity building in negotiation focus on enhancing the skills, knowledge, and abilities to individuals or organization to effectively manage and participate in negotiation process. This can include training or communication, conflict resolution, strategy development, emotional intelligence, and legal framework. Capacity building goes beyond just skill. It involves strengthening institutional structure, fostering collaborative network, and increasing awareness of ethical consideration by investing in training and capacity building. Negotiator can improve their decision making, adapting change contexts, and create more sustainable, equitable agreements. This is particularly important in complex negotiation such as international diplomacy, cooperative mergers, and labor relations. Public awareness. Public awareness in negotiation involve educating and informing the general public or specific shareholders about the negotiation process, their right, and the potential outcomes. It play a crucial role in fostering transparency, accountability, and public participation in decision making process. Increased awareness can help individual or communities better understand the implication or negotiation, whether in politics, business, or legal context, and empower them to advocate for their interest. Public awareness campaign of focus on highlighting the importance of ethical negotiation, legal framework, and need fair representation, ensuring the negotiation and conduct the broader societal interest it mind. Thank you so much.